Generally, judges need to hear the facts directly from the horse's mouth, so to speak, and generally speaking, that first-hand witness should be in court so that others have the chance to cross-examine or ask follow-up questions. Hearsay is the opposite of this. The rules define hearsay as an out-of-court statement repeated in court and offered to convince the judge that the statement is true. Most hearsay is not admissible. So generally, you can't say, "My brother Joey told me that Laura sold Tim's golf clubs at a yard sale." If that information is relevant, Joey needs to be present and testify that he saw the clubs for sale at Laura's yard sale. Also, you cannot say what your child told you. That's also hearsay. This same rule applies to any written statement from a witness. The witness still needs to be present to testify, not through an out-of-court written or oral statement. An affidavit, even though sworn to under oath, is still hearsay, and unless it fits under one of the exceptions to the hearsay rule, the judge will not be able to consider it. There are important exceptions to the hearsay rule. The most common examples are statements made by the other party, statements made immediately as an upsetting event occurs, and statements showing a person's present sense impression or state of mind at the moment. Again, these statements can be oral or written, such as a letter, text, or Facebook posting. You can offer these types of statements as evidence. Another important exception is a statement that is not offered for the truth of the matter asserted. For example, if Joey told Laura that Maine was invaded by Argentina last week, Laura's testimony about that would not be admitted to prove or disprove the fact of an Argentinian invasion, but it could be admitted to prove that Joey was delusional. Now let's check in on Judge Kennedy later in the hearing with our divorcing couple.
Judge, I have an affidavit signed by my neighbor Judy that supports my testimony that I can't work. Can I offer this, please?
Objection.
Grounds.
Hearsay.
Sustained. Ma'am, even though it's signed under oath, it's still hearsay. Your witness is not here.
Do you understand why the wife was not successful in getting the judge to read her document? What rule did she break? If you guess that it was inadmissible hearsay, you're right. What should she have done? She should have arranged for the neighbor to come to court to testify. Now let's watch another example.
So, Mr. Johnson, what happened next?
I saw your wife grab your daughter by her hair, and then your daughter said, "Mommy, don't hurt me again."
Objection.
Grounds.
Hearsay.
Overruled. Present sense impression. That's admitted.
So you can see that John was more successful here. First, he had his witness in court to testify, rather than trying to repeat to the judge what the witness saw or said. Second, why was the witness allowed to repeat the daughter's out-of-court statement? That is because the daughter's statement is treated by the rules as a subjective present sense impression. In other words, it was offered to show that the daughter was in pain at the time the event occurred. This is an exception to the hearsay rules. So think carefully before you get to your court hearing about how you are going to present your case. Again, make an outline for yourself. Think about each fact that you need the judge to understand in order to decide the issue. Strip out all the other information that is not essential and that the judge will not want to hear. Make sure that each statement and each piece of written evidence passes 3 tests. First, is it relevant? Second, is it hearsay? And for documents, is it authentic?